How's it going, everybody? This is Attorney Anthony Miranda with the Firearms Policy Coalition. Today, I want to bring to your attention a few recent actions by the Supreme Court. First, the Supreme Court recently denied certiorari in two Second Amendment related cases, Bolletetti v. U.S. and Graywall v. Defense Distributed. Bolletetti involved taxation of suppressors under the National Firearms Act. Defense Distributed involved an appeal by the New Jersey Attorney General against defendant, which related all about 3D printing in a website. In Bolletetti v. U.S., the question presented to the Supreme Court was whether federal criminal punishment of the receipt and possession of unregistered suppressors under 26 U.S.C. sections 5861 subsection D and 5871 exceeds Congress's powers to tax under Article 1, Section 8 of the Constitution and violated the 10th Amendment. In this case, Mr. Bolletetti was convicted and sentenced to 60 months in federal prison for possessing a firearms suppressor that had not been registered in his name under the National Firearms Act. Bolletetti's defense argued that his 5-year prison sentence for failing to register and pay the $200 tax stamp on the suppressor, as required under the federal law, was a violation of his rights because the NFA's tax isn't really a tax at all. Instead, they claim that it functions as a pretext to coerce conduct reserved to the police power of the states. As of last week, the Supreme Court denied certiorari in this case, therefore declining to address this controversial issue of NFA taxation and criminal punishment for failing to register and pay the $200 tax stamp for suppressors. In Graywall v. Defense Distributed, the New Jersey Attorney General sent a cease and desist letter back in 2018 to defendants, warning that the group's plans to set up a website to allow individuals to download schematics that would allow them to build a firearm with a 3D printer would be a violation of New Jersey law. When Defense Distributed did not respond, the Attorney General launched a lawsuit seeking to shut down the group's website. In response, defendants sued Graywall in a Texas district court, arguing that the AG was trying to enforce an unconstitutional law against them. The district court in Texas agreed with the Attorney General, but that decision was reversed by the Fifth Circuit Court of Appeals. Attorney General Graywall then sought certiorari from the Supreme Court for reversal of the Fifth Circuit's decision. The Supreme Court ultimately denied certiorari, therefore the Fifth Circuit's ruling in favor of defendant Defense Distributed stands as is. The Supreme Court has also redistributed New York State Rifle and Pistol Association v. Bruen, formerly known as the New York State Rifle and Pistol Association v. Corlett, for conference this Thursday, April 1st of 2021. In this case, the court is being asked to weigh in on New York's subjective issue licensing laws for carrying a firearm in public. New York State forbids ordinary law-abiding citizens from carrying a firearm outside the home without a license. To acquire a license, an applicant must demonstrate a proper cause. This requires more than just a desire to exercise the right protected by the Second Amendment. It requires more than just a desire to protect oneself or a family, more than good moral character and they want to carry a weapon, and more than living or working in a high crime area. Instead, proper cause requires an applicant to demonstrate a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. So by its very definition, ordinary citizens are prohibited from exercising the right. The fact that the court relisted the New York State Rifle and Pistol Association petition for the April 1st conference after first considering it at the March 26th conference is an encouraging sign that the court may grant certiorari. These conferences come in the wake of the recent Ninth Circuit Young v. Hawaii decision last week, which found that there is no right to carry firearms in public. With widely varying circuit court opinions on the right to carry firearms in public, including the recent outright statement by the Ninth Circuit that individuals have no such right under the Second Amendment, this issue appears ripe for the Supreme Court to finally address. FPC has filed a brief in support of plaintiffs, authored by FPC's Director of Constitutional Studies, Joseph Greenlee. That brief, along with additional resources on these three cases and more, can be found at firearmspolicy.org. While you're at it, please head on over to joinfpc.org. Your donations go directly to helping our team fight against these 2A infringements. Once again, this is Attorney Anthony Miranda with the Firearms Policy Coalition. I'll see you guys next time.